District of Texas is now in session. Simply adjourned. Tiff Hunter is on the floor.
Please be seated. We have one case on the docket today, Harris County Department of Education versus Paradigm Construction. We've given both sides 15 minutes. Would the appellant like to save time for rebuttal?
Yes, Your Honor. I would reserve 4 minutes, please.
4 minutes? Okay. Let's get our number right, and we're ready when you are.
Good afternoon, and may it please the court. My name is Corey Rush, and it is my honor to represent the Harris County Department of Education in this matter. The issue before the court here is about jurisdiction and whether or not the balance due and owed under a contract is a jurisdictional fact for which this court can review the record evidence and determine whether or not governmental immunity has been waived on behalf of HCDE under Chapter 271 of the Local Government Code. The at issue here is the contract between HCDE and Paradigm Construction for the construction of an adult education center school. That the contract explicitly provides in no uncertain terms that there are no damages for delay and that the only remedy for delay is additional time. And I think it is important to note that it is undisputed in the record that for the time period that is the central part of this complaint especially, which is from the start of the project to the issuance of the permit from the City of Houston, Paradigm was credited back with that time. And that is HCDE's contractual obligation, was to credit that time back upon reviewing the request.
Well, you only quoted part of the contract. It is the sole remedy, quote, unless the same shall have been caused by acts constituting interference by the owner which materially interfere with contractor's performance.
Yes, Your Honor, that is part of the next line in that clause. And then to finish that line of that clause is about Paradigm having provided HCDE notice of such alleged interference and given that notice that the interference continued thereafter. There's never been an allegation.
You didn't brief any of this in the trial court. You did not give them an opportunity to respond with evidence.
We did not brief that in the trial court. It was not raised until their appellate brief when we did it in reply. That is correct. So, and I think the main point there is
but for you to prevail on this point, you would have to prove that they cannot provide evidence or they cannot amend their petition. And
yes,
you haven't proved that.
That is correct. That is not in the record, Your Honor. That is
okay.
correct.
Well then, why would it be a ground for us to conclude that jurisdiction was lacking if we have to send it back for those findings?
Because there is record evidence, it is in the reply, that there has never been an allegation or proof in this record, and this is a thick record as Your Honor saw, that has ever at one point ever alleged that HCDE interfered with the performance of the contractual.
But if you didn't raise it below and allow them to present evidence, we have to remand.
It was raised in their summary judgment. We did respond to that. And it is in this record before this court with argument with every single alleged notice of interference claimed in their response and addressed in our reply. And just like in Russ State Hospital versus Black, jurisdiction can be raised for the first time on appeal. And here, for the benefit of the court, there is record evidence that is pointed to and briefed by both parties. That should be sufficient for this court to be able to analyze its jurisdiction under that point. The main point for all of this, though, is with regard to that section, the only claim damages in this whole case are about delay damages, monetary damages that are expressly disallowed under this contract. And there's never been an allegation that HCDE interfered or that we got notice or that we did not correct such behavior after receiving such notice. And then looking at the clause itself, HCDE did its contractual obligation to provide more time. This is a breach of contract claim.
What proof did you put in your plea to the jurisdiction on those points?
On the plea to jurisdiction?
Yes, this is what we're here on.
No,
the
I'm
plea
sorry,
to the jurisdiction.
I didn't hear the first part
yes,
of the question.
We're here on your plea to the jurisdiction. What evidence did you put into the record about the delay damages?
We put in the evidence that the contract was signed in November of 2021. A limited notice to proceed was issued in December of 2021. Work was performed under the limited notice to proceed until work stopped in February of 2022. The permit came through April 7th, 2022, as did the full notice to proceed, and the denial of the claim on April 21st, 2022, when Paradigm first brought up their claim for delay damages for the period between February and April of 2022. The evidence is in the record that that claim was denied, and the reason for the denial of the claim was citing back to the contract that both parties signed in section 8.3 that says this sort of damage you are claiming is not allowed under this contract. Your remedy is more time, and more time is granted to you. That evidence is all on the record and was presented in the plea of jurisdiction. The challenge before this court, of course, is that the cases that have had the opportunity to come up under 271 of the local government code have procedurally been either a pleadings challenge, like this court handled in the ICI construction case, or in Zachary construction, where it was a post-trial plea to the jurisdiction. What the procedural posture of this case is different because this is coming under the second option under Miranda, where Miranda gives the court two analytical frameworks, right, to look at a plea to the jurisdiction. It's either a pleadings challenge or it's an evidentiary submission to call into question an issue of jurisdictional fact. And when that second vehicle is the procedural vehicle to be in front of the court, then the analysis is akin to that of a motion for summary judgment, where the evidence is considered, even evidence that goes to the merits is considered, as long as it is going to a jurisdictional question. And Your Honors, the jurisdictional question here before you on a question of jurisdictional fact is the damage that Paradigm is seeking in a balance due and owed under this contract? And the contract makes it very clear that no, it is not. And what HCD is asking you to do in this case really isn't that much different from what this court did in the police construction case from 2024, which was an evidentiary challenge. It was akin to a summary judgment where the claim damages were not found to be due and owed under the contract. This court entertained that argument and ended up ruling in favor of Harris County on the claim, saying that governmental immunity had not been waived under the statute because of the particular jurisdictional facts in question in that case. That's no different procedurally from what HCD is here asking you to do today, and why we believe that the trial court erred in denying the plea to jurisdiction. This contract was clear. This contract was signed by both sophisticated parties. There were no changes requested to the contract during the bidding process.
Well, the question is the delay by Harris County, right? I mean, did Harris County cause the delay? And that's their argument.
That is their argument, and it was explicitly the Harris County Department of Education caused delay, whether it's seen as directly Harris County's fault for the planning process of the City of Houston taking too long, or whether it was Create, the architect, who also had that obligation, that shared obligation. That is contemplated directly in the provision that is at issue here under 8.3.1. Number one is acts or omissions or negligence of Harris County, the architect, Harris County Department of Education, Harris County Department of Education, the architect, or any of its employees or agents thereof. That's the first possible waiver in the contractual remedy at issue. It's specifically contemplated in the agreement, and it was signed, and it was enforced and enforceable. And with that, with the allegation being that HCDE should have done something differently through its architect to get the city to issue the plans faster, that's contemplated in the agreement. That was waived in the agreement. The Supreme Court has made it very clear in Zachary Construction and many other times that parties are free to negotiate and allocate the risk of such loss as delays. That's what happened here. And if we can't enforce our contract, I wish handshakes were good enough, right? But we have a contract, we're allowed to enforce it, and the Supreme Court has said that unless the remedy is somehow limited in the contract itself, then delay damages that are available under law are as much a part of the contract as if they were written therein. That unless the parties agree otherwise is key, because here the parties did agree otherwise. The parties agreed here that there were no delay damages. That should be enough for the court to be satisfied that this is not a balance due and owed under the contract. That is a jurisdictional fact, and HCDE has maintained its governmental immunity from suit and liability because of the contract itself eliminating these damages, especially when you take into account that under the 5 different ways that a plaintiff can undermine a no delay for damages clause, according to Zachary, collecting the cases and saying, here's the 5 remedies we see in state law for this, none of them are at issue here. There's no allegation of fraud or mistake or bad faith negotiations. There's just the only thing that they have alleged at any point in this case is that HCDE should have moved faster with the permitting process, and that goes back to the plain contract language. And we're also only talking about, in contrast to ICI, which was a 3-year delay, we're talking about November to April here with the first claim, the first notice of claim that Paradigm filed saying that they were really only delayed from February 2022 to April 2022 when the critical path work was stopped after they had the limited notice to proceed in December. So we're talking about 2 months in comparison to 3 years where the court said there might be a fact issue about whether the contractor could walk away based on the length of the delay.
Thank you.
Thank you.
May it please the court. The trial court correctly denied the plea to the jurisdiction. The standard is, did we allege a waiver of immunity under 271? In Zachary, the court said, and Justice Wilson wrote in ISI, did we allege a substantial claim? Facts with evidentiary support to support a waiver. It's undisputed, there's a contract. It's undisputed that this contract, the provision at issue, provides for delay damages because of owner's interference. My friend on the other side argues we never mentioned interference. They filed a combined plea to the jurisdiction, a no evidence summary judgment, and a summary judgment. They didn't just challenge our pleadings. The Harris County Department of Education also challenged our jurisdictional facts. The record contains our response. We pled interference. We introduced almost 28 exhibits, including the report of our expert, Michael Purnell, detailing our damages. And with respect to notice, everything Mr. Rush has argued is a merits issue. In this record before the trial court were our notices of the claim for delayed damages as permitted under this contract. And frankly, even if this provision wasn't in there, Zachary plainly says you can't interfere. You can't have wrongful, willful, malicious conduct and just eviscerate these delay damages for owner-caused damages. We sent a letter April 5th, 2022. By happenstance, the permit was issued 2 days later. April 12th, we sent a supplemental letter. December 20th, 2022, we sent a letter about the decommissioning of existing power interference. HCDE failed to do what it needed to do to ensure that the power came on as it should. February the 17th of 2023, another letter. March 1st of 2023, another notice letter. April 20th, 2023, a very comprehensive letter, and May 16th. Whether or not the notice was reasonable, was enough under 8.37 is a merits question. To provide some context for what's going on here, in our response, supplemental response to their plea, we quoted the deposition testimony of James Colbert. Question: so you were willing to pay money for delays? Yes, and that's at volume 3, clerk's record 2272. And costs resulting from delays? Yes. To Paradigm? Yes. Answer, I was willing to. Actually, twice I was willing to do that. But his greed, and then it goes on. It's a merits question. Did we ask for too much? Did we ask for not enough? Not at issue here. What's at issue here is that we pled and have satisfied the standard, plead a contract, plead a breach, plead a basis for the claim. So what happens when there's a plea that challenges jurisdictional facts? Well, it's a different inquiry, as this court notes. It's whether we raise a genuine issue of material fact on the jurisdictional claim. Absolutely we did. We don't have the burden to prove that we will ultimately prevail, only that immunity has been waived. They claim our damages are too high, perhaps they're less. That's not an issue, that's a merits issue. When you read their opening brief, the complaint is interference. We file our response and they pivot to notice. Well, they didn't give notice. Notice is not a merits question. It is a merits question. It is not a question that should be addressed when the challenge is to jurisdictional facts, and we've submitted enough to raise a fact issue. With respect to the owner caused delays, we pleaded those. Clerk's record 544 and 545, page 3 and 4 of the second amended petition. The 6-month delay in issuance of the building permit. They had over 30 resubmissions. And the record will reflect they paid a claim for a delay in the issuance of the permit to begin construction. They just chose not to pay this one because James Colbert wanted to interject the merits here.
Let me ask you this.
Yes.
Do you feel that the arguments in Harris County's brief were before the trial court?
That is an excellent question, Chief Justice Christopher. It's a moving target. So in the plea to the jurisdiction, they said there is no balance due and owed. On page 2 of their plea, they claim that HCDE asserts it retains governmental immunity because Paradigm's breach of contract claim seeks damages over and above those permitted by law. That was their complaint there. And they misunderstand the provision at issue. Interference, the parties agreed that if they interfered and those interference caused delays, we would be compensated. This is not a SACRI wrongful, it could be, but we don't need that. We have a provision that addresses that. That's what their plea said. Then they made different arguments in their motion for summary judgment, which was denied, both the traditional and the no evidence. But if you just look at their plea, that's what they said. However, because we introduced about 28 exhibits or so, they're in the record, they're described in our response, the trial court had before it sufficient information to conclude that we pled a substantial claim as required under Miranda and its progeny.
Well,
Yeah.
Justice Christopher's question was, is the Department of Education raising claims in this appeal that were not raised in the trial court? And as a corollary to, and I haven't heard an answer to that, and as a corollary to that, if so, is there any reason to remand if indeed you put in all the evidence there is to put in? Is there anything more to put in?
No, there is no reason to remand here. If you could, under existing precedent, decide that we should be afforded an opportunity to replead. We pled everything we need to plead. The trial court had the contract, it had our notices of claim, it had evidence to establish interference, it had evidence to establish our damages. To answer the question directly, they have made again, their arguments are a moving target. They have
So
made arguments.
You don't want an opportunity to replead, and you don't believe you need any further evidence?
Your Honor, at the end of the day, if this court decides that they have somehow convinced you that we did not meet our standard under this court's own jurisprudence in ISI and under the Texas Supreme Court's precedent, that Paradigm has not pled a substantial claim which pleads facts with some evidentiary support that constitute a claim from which immunity is waived, then of course remand us and don't. But I think this court should affirm the trial court's ruling. One of the other issues that has arisen is the Harris County Department of Education filed a counterclaim against us for breach of contract. It's in the record. Under RIADA and under the City of Dallas versus Albert case, there is a strong argument to be made that they have waived their jurisdictional challenges altogether with respect to the claims made the subject of their counterclaim, and that subsequent dismissal does not somehow erase the fact that they waived immunity as to those claims. And City of Albert is 354 Southwest 2nd 368. I think the ISI is on all fours, despite the fact that it was a challenge to the pleadings. Justice Wilson noted, Your Honor, you noted that you're going to presume that the analysis is the same, the requirement that you plead a substantial claim is the same when there is a jurisdictional challenge to the facts. You're going to presume without deciding that the substantial...
Yeah, I was going to say,
yes, presume without deciding.
The first time you said it, you left out without deciding.
Oh, yes, I understand. Yes, I think you're right. I think you're right on that. I thought about that. I couldn't come up with convincing reasons why that would be different. And so I think this case tracks ISI pretty well. Again, we don't need to establish that we would win on the merits. We need to establish that we pled a substantial claim, that we had a contract is not in dispute, that there's a provision that allows delay damages for owner interference that causes those delays is not in dispute, that we gave notices and they're in the record is not in dispute. Whether those notices are enough or sufficient or timely is a merits question. Have we...
So
yes, ma'am.
our court has seemed to conclude that not providing proper notices is an immunity question, not a merits question. Are you familiar with that line of cases?
And yeah,
I know we differ from other courts of appeals on this point. So how have you negated their notice issue?
we provided evidence of our letters of notice. Whether or not they're reasonable is a fact question. That's for a jury to determine. Whether or not, there is sufficient as, in the context of all of the facts and back and forth with these folks, is a fact question. So there is nothing about this notice that was required under the contract that is jurisdictional. You could even have a textual argument where the provision says, let me just get that in front of me. It says, unless you provide notice. There is a strong textual argument to be made that the words "and then only to the extent" mean if, and if they do, we provided notice. We absolutely provided notice. And the conduct continued. The record shows that. If you look at the notice, they don't stop. We continue to make claims for these owner cost delays. So the record speaks to that. HCD created the conditions for the delay. They were responsible for securing the permits. They were responsible for executing the documents that would allow us to get the sidewalk easement. They were responsible for the delays with the center point because they never signed that documentation. And another thing that's very telling about their callous, willful, egregious conduct, the testimony from James Colbert that we cited to Volume 3, 2272, and we asked him about paying an identical claim, identical, same delay. And Mr. Colbert says, question, Mr. Colbert, if subcontractors are passing on price increases and a general contractor is passing them on to the owner, do you believe that's great? Answer, well, you wanted to know, I'm sure you're curious, on why I would pay one and not the other. Do you believe Paradigm was due money? The answer is yes. So they understood that clause 8.37 required them to pay these damages in the form that our expert testified through his report. They just chose not to. And they chose not to because they have some mistaken belief that these merits questions are somehow jurisdictional bodies. And if the court has no further questions, I thank you for your consideration.
Thank you.
Your Honors, I will try to be very cognizant of my time. The first thing I want to note is that the questions were directed and the presentation was directed a lot at the issue of notice and notice of interference. And I think there is a distinction in this contract in the way this is being argued. There's a difference between the delay and interference. What interference was HCDE ever accused of doing? It was always, it took too long in the permitting. And then we got a notice 2 days before the permit was issued and the notice to proceed was issued. And with that notice of claim, it was just this time went too long. It wasn't HCDE, you did this. HCDE, you need to stop doing this. There's nothing like that in this record. There's nothing about HCDE interfering, doing any sort of malicious, bad faith, or whatever word was used in that.
What is the exact language of the notice provision?
The exact language of the notice provision is that any delay unless the same shall have been caused by the acts constituting interference by the owner, which materially interferes with the contractor's performance of the work, and then only to the extent that such acts continue after contractor's reasonable prior written notice to owner of such interference. There was no notice and then continuation of some sort of interference, bad act interference. The claims were always, this is taking too long. You should have done this with securing the easement, whatever it might have been, and HCDE corrected and issued more time based on what the contract said, at least with regard to the initial delay from contract to notice to proceed, and with the center point issue that came down later with the 59-day addition to the substantial completion deadline. So with this, yes, there are letters in the record that reiterate Paradigm's claims that they want money that's not due to them under the contract, that they think they should get paid because there were price escalations and difficulties securing contractors following COVID and with inflation and everything that was going on in this relevant time period. There's no dispute. That's what the expert also testified to, was these price fluctuations and the market was more volatile. No dispute. We all lived through it in some way, shape, or form. The issue is it's not evidence of interference. And even with looking at what the Supreme Court jurisprudence says in Miranda and its progeny, the And probably the most important and notable case in this would be an employment case, Alamo Heights ISD versus Clark, where you can really see how deeply the Supreme Court was willing to dive into the merits of a claim to satisfy itself of the resolution of a jurisdictional issue. That opinion goes deeply into the merits of the claim. And this court itself, in the Harris County versus Police Construction unpublished opinion, cited to Alamo Heights when it said, when the plea challenges the existence of jurisdictional facts, we must move beyond the pleadings and consider the evidence when necessary to resolve the jurisdictional issues, even if the evidence implicates both subject matter jurisdiction and the merits of the claim. So this distinction between merits and jurisdiction, that's not a bright line. That's not a railroad track we have to stick on when the merits implicate jurisdiction, and here they do, and the record is replete with it, but most especially it's true that this contract says, Paradigm, you don't get delayed damages, and those are the only damages being requested in this case.
How do you respond to Eppley's argument of waiver by the virtue of the counterclaim?
That counterclaim under RIATA, the waiver would apply only to the extent that there's an offset between the two claims, and the issue here is there's not an offset between these two claims. The counterclaim is dismissed out, and there's there's never been an argument about the offset. There's never been an argument about the waiver until this point. I just don't believe that there's any waiver bar at issue here under RIATA. And with that, Your Honors, unless you have any further questions, I will give you back your days. Thank you.
Thank you very much for your interesting arguments. The case of Harris County Department of Education versus Paradigm Construction is submitted, and we are adjourned.
All right.